Welcome to the third episode in the second season of Justice Center Weekly, a podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and joining us today is John Carpay, president and founder of the center. John's here to give us some perspective and comment on the case of Jasmine Grandel and Daryl Mills in Saskatchewan, where the province's outdoor gathering restrictions during COVID are being challenged. The case is known as Grandel versus Government of Saskatchewan, and last week it was in appeal. John, as I understand it, one of the issues here is the rule of law, or rather, the lack of it, the unequal application of the law. Perhaps you can start there, because I know what happened with regard to protests in Saskatchewan, in some ways, happened right across Canada. Can you tell us about that, to put the Grandel case in perspective?
Yeah, so the Saskatchewan government during lockdowns made it illegal for outdoor gatherings of more than 10 people, all while allowing indoor gatherings of 30 people, or in some cases 50 people, in all kinds of different contexts. But if you were outdoors, a gathering of 11 people was illegal, even if they were socially distanced from each other. That was completely irrational, and even the Saskatchewan government conceded that outdoor transmission of COVID was negligible, and the Saskatchewan government did not produce as evidence one single case, one single example anywhere in the world where there was spread of COVID through an outdoor gathering. There's just zero evidence. What made the situation even worse was that the Regina Chief of Police and other police officers, the same people that are handing out tickets to Ms. Grandel and other outdoor protesters, they themselves participated in a Black Lives Matter protest in 2020. And there were huge numbers of people. And we saw the same thing in Alberta, British Columbia, various places in Ontario. The Prime Minister participated in an illegal outdoor protest that was in violation of the health restrictions. And so this reinforces the fact that these restrictions were utterly political, not scientific, unless we believe that somehow COVID is sensitive to political views, and that COVID knows that it should not spread at an anti-racism protest, but that COVID does spread at an anti-lockdowns protest. And
yeah,
so,
from what I recall, the excuse was that, this is just so important. This issue is so big. It outweighs the need for restrictions at the time. And that was kind of the scientists were actually making that argument as well.
Oh, yes. Yeah. The scientists said that racism does so much damage to health that we have to, disregard. Yeah. It was in the United States as well. Let's disregard our COVID restrictions if it's an anti-racism protest. And that's a breakdown in the rule of law, because the rule of law means several things, but one of them is that the law is applied equally to people regardless of personal characteristics, including skin color, sexual orientation, religion, national origin, ethnicity, and political convictions is one of those. So when you've got a law, you enforce it across the board, and you don't say to one group of people, well, we really like your politics, so we're not going to enforce the COVID restrictions against you, but for another group, well, we don't like your politics because you're protesting in defense of your charter rights and freedoms. So we're going to enforce the law against you and hand out fines. So it was quite tragic at we lost in the lower court, and the judge did a very cursory, superficial, and inadequate analysis by not requiring the Saskatchewan government to produce compelling evidence showing that this restriction on outdoor protests was going to actually save lives. It was like so many other court rulings in 2022 and 2023, where the government was not held to the constitutional requirement of actually justifying demonstrably with persuasive evidence that the restriction on a charter right or freedom was doing more good than harm. So here it was just Saskatchewan government basically admitted in court they were just throwing darts in the dark, and well, this might help. It might be doing something good, and then the court just rubber stamps it, and that is not the way that it's supposed to be.
Yes, I do believe that that original judge had said something about, the disease was wreaking havoc across the province with the lives of Saskatchewan citizens.
Catastrophic loss of life. Catastrophic loss of life was one of the assertions in the court judgment. And this is not backed up by the facts. I mean, even if you're somebody who agrees with COVID restrictions, there's no denying when you actually look at the impact on population mortality that COVID was not the Spanish flu of 1918 that it was made out to be by the likes of Dr. Neil Ferguson of Imperial College London, who actually started the worldwide panic by expressly making a comparison and saying that COVID would be like the Spanish flu of 1918, which killed literally tens of millions of people, most of them in their 20s, 30s, and 40s, left a lot of children orphaned. COVID was totally different. COVID was about 1% of the damage of the Spanish flu of 1918 in terms of the number of people that died as a percentage of the population. And also, one of the things that scientists were using prior to lockdowns in 2020 was years of life lost analysis. And this is a scientific way to measure the impact of a cause of death, whether that's earthquakes or suicides or diseases or illnesses or car accidents. You look at the age of death that a particular cause of death is wreaking on the population. And the reason for doing this is that we are all going to die. And so, death is not an option. It's going to happen. But it's significant if there is an illness that is killing thousands of 5-year-olds. It has a different impact on the overall population mortality as compared to an illness that is afflicting people in their 70s and 80s, particularly people who are already very ill and they're in their last few months of life. Is not to say that we shouldn't do our best to protect everybody from illnesses, but there's a huge difference between the Spanish flu of 1918, which killed people primarily in their 20s, 30s, and 40s, versus COVID, which typically had a very severe impact on people who were elderly and already suffering from heart disease and emphysema and diabetes and multiple other illnesses.
Right. And I think that original judge, he was buying the panic that was being sold by the media.
Absolutely.
But he was also excusing the unknowns, I guess. That was one of the excuses we heard through several judgments, I think, on these matters. Well, it was a situation where so little was known, so we just thought it would be best just to shut everything down, et cetera, et cetera. And on balance of probabilities, it probably did something good, although we don't know.
Well, there you raise another big issue again. The Constitution of Canada, the Charter, Section 1 says that governments can violate our freedoms of expression, religion, conscience, association, peaceful assembly, mobility, bodily autonomy, etc., provided that the government justify demonstrably with persuasive evidence that those anti-freedom measures are actually bringing about more good than harm. The Oakes test, Supreme Court of Canada 1986 ruling in R versus Oakes, is more. There's more to it than that, but this is a key component of the Oakes test, is that the onus is on the government, not on citizens, on the government. The onus is on the government to show that any freedom violating measure is actually bringing about more good than harm. And once again, this court ruling, the lower court ruling in Grandel, is devoid of proper analysis of the Oakes test. And I think one of the worst errors in it is an abuse of the precautionary principle. So the judge said, well, we don't know about this virus, so therefore we're going to take precautions. But you could equally say, and you should say, and the court ought to have said, we don't know about how damaging lockdowns will be. And so we should exercise the precautionary principle and not force people into isolation and loneliness and depression and drive people towards drug overdoses and suicides, destroy livelihoods, destroy small businesses, destroy the life savings that people have wrapped up in their small business that's being destroyed by lockdowns. Why should the precautionary principle be applied only in one direction to say, well, we don't know about the virus? But here's another thing: is when these measures were in place, we did know a lot about the virus, and we knew that outdoor protests, outdoor gatherings were not a source of transmission. How do we know this? Well, the Saskatchewan government had every opportunity to put evidence to that effect before the court, and it did not do so. Saskatchewan conceded that that there's no evidence anywhere in the world of outdoor protests when not combined with indoor events. Okay, so there's a distinction there. If you have some kind of a event or rally that's both indoor and outdoor, okay, fine. But there is no evidence from any country in the world that outdoor gatherings were significant in spreading COVID. So it's just zero science to back it up. And then the judge wrongfully applied the precautionary principle only in the direction of, well, maybe this measure saved lives, without paying any attention whatsoever to how the lockdowns were wreaking havoc on children's mental health and adult mental health, and just the well-being of people that comes about when we can freely exercise our freedoms of association and peaceful gathering.
How much do you think this issue of hypocrisy is going to work into an appeal argument at all? I don't know whether it actually does, but that was the golden peg for the outrage against the governments, the fact that they would allow these protests. I think there were George Floyd protests with Black Lives Matter, and then, disallow other ones. That seems to be what caused the most outrage. How does that sort of work in a rule of law situation?
We'll have to wait and see what the Saskatchewan Court of Appeal says on that. So they heard the appeal a few days ago, and we can expect a judgment in 1 month, 3 months, 6 months, 9 months, whatever, whenever it comes out, and we'll see if this lower court ruling is upheld or not. Okay.
I want to move on right now to another topic. This is one that's a little more, I guess, out in the public right now. It's making a lot of noise, and that is the gender policies of the Alberta government of Danielle Smith. We're finding that there's a lot of pushback from both directions. There are those who oppose her, and they're the traditional, I would say, progressives that have been supporting the transgender agenda. And then we find that there's some evidence now of transgender people siding with Danielle Smith. So, it's a hot debate out there right now. I know you've written about this, and of course we've been covering parental rights in the courts and in our podcasts. Where are you going with this right now yourself? What do you see here happening?
Well, it's very likely that these new policies are going to be challenged in court, and that will happen when they are formally put into either legislation passed by the legislature or government policy. And when that happens, when there is a written government policy that says, and just to recap briefly, some of the points are that children under 16, if they wish to undergo a transgender social transition where a boy will start using a girl's name and female pronouns and using the girls' washroom and joining girls' sports teams, etc., that he cannot do this without the knowledge and consent of his parents if he's under 16, and vice versa if a girl under 16 wants to start dressing like a boy, using a boy's name, male pronouns, etc. Under 16, you need parental consent. No puberty blockers for kids under 16 without parental consent. And I believe, and I stand to be corrected, for 16 and 17-year-olds, it might be possible with parental consent. Puberty blockers can create irreversible effects on the human body. You only get one chance at puberty. So if you take the puberty blockers and do not, develop naturally from boyhood to manhood or from girlhood to womanhood, if you've been on puberty blockers throughout your teens, if you hit the age of 18, you don't then get a second chance to go through puberty again. It's over. And so these are life-altering decisions that can create permanent, irreversible sterility for kids who, after the age of 18, they might decide, oh, well, I would like to become a father, I would like to become a mother, and that opportunity is lost forever. So these are measures to protect children, and I do predict that there will be court challenges against Danielle Smith's policies.
But I noticed the public outcry, that is the protests. They may be loud, but they're not that big. And I do see online a lot of support for these policies. It seems to me, at least, sort of my sense of the issue is that there's a lot of support for them. And interestingly, just before we got on here, I found an article that appeared in the New York Times. This was actually from February 2nd. Pamela Paul in the New York Times. So the headline is, "As kids, they thought they were trans. They no longer do," unquote. So it's getting major play now, this issue of, I guess, trans regret, and surprised to see such a long article detailing this regret. In
the New York Times of all publications.
New York Times of all places, yeah. Yeah, it was listed as an opinion piece, but it was more like a feature piece for a magazine. And it seems like it's mainstreaming now, this pushback. And that's why I thought it would be worth mentioning a couple of stories, actually. That was one in True North, February 2nd as well. And that was titled "A Step Forward, LGBT Albertans React to Danielle Smith's New Gender Policies," where they actually found some very supportive transgender people for these policies. And of course, she had mentioned, that is, Danielle Smith had mentioned that she had interviewed several transgender people, and this was some of her input into crafting these policies. So I don't know, I think it's going to calm down pretty quick here.
It is very mainstream.
Yeah.
The United Kingdom and Sweden, Norway, Denmark, the Netherlands countries have kind of gone all the way in what I think is the wrong direction. That's very harmful to children, and they've been doing puberty blockers and even surgeries, etc. And they are all backing away from that. In the United States, you've got lawsuits from adults who say legitimately that they did not have the capacity as teenagers to make these permanent decisions about their bodies, and they are suing. And it's a lot easier in the United States to sue than in Canada, because typically in the US you don't have the court costs awarded against the unsuccessful party. So in the United States you can sue somebody, and if you lose, you walk away from it. You might be out of pocket for your own legal fees, but you don't have to pay for any of the other side's legal fees. Whereas in Canada, if you sue somebody and lose, you could be looking at $20,000 to $100,000, $200,000 that you have to pay to the successful defendant. And that cuts both ways as well. If you're a defendant and you don't settle with the plaintiff and it goes to court and you lose, then the defendant has to pay a portion of the plaintiff's legal bills. So lawsuits in Canada are less frequent and more difficult than in the US. But certainly in the US, you've got people that are adults who are suing their the doctors and perhaps their own parents. I don't know, but they're suing over and political activists that talk them into it. So what Danielle Smith's policies, they are quite mainstream. And the key point I want to dwell on is that they do comply with the Charter. The Canadian Charter of Rights and Freedoms, Section 7, protects the right to life, liberty, and security of the person. This has been interpreted more than once by the Supreme Court of Canada as including the right of parents to make choices about their children's education and moral upbringing, and that parents have a duty, an obligation, a responsibility to look after their kids. And with that duty and obligation, there is a need, whether you call it a right or not. I mean, some people are fixated, there is no such thing as parental rights or not. I think there are parental rights, but the key point is that when you have a legal duty and obligation, you need the capacity to carry that out. So parents are legally obligated to love and care and support and nurture and protect and look after their children, to look after their children's needs. The only way that a parent can do that is to know all about what is going on in their child's life. If you don't know what's happening with your 13-year-old or 15-year-old or even your 17-year-old at school, you cannot possibly carry out your parental obligation to look after your children. So there are Canadian court rulings that uphold the right of parents to make to care for their children, and that would include being involved with life-altering decisions. I mean, if your child is same-sex attracted, or if your child is struggling with gender identity, then we need parental involvement. And we need parental knowledge about what's going on. You cannot keep parents in the dark. Now, what the transgender lobby is pushing is a narrative that parents are dangerous and abusive, and parents should be kept in the dark. And that's just absurd. Yes, there are abusive parents. There are parents who will, beat their child if their child, and I think this is a very, very, very small number, but there are parents who, if their son or daughter says, "Hey, I'm same-sex attracted," or "I'm struggling with gender identity," or, a boy goes to his parents and says, I feel like I'm a girl trapped in a boy's body. There's a tiny number of parents that would be abusive. We have child protection services for that. We have a legal obligation on the part of teachers who must, by law, report to social services when they have reasonable grounds to believe that a child is being abused or being severely neglected. Teacher must report to social services. And in fact, I think in some provinces, and I stand to be corrected, that's the law for everybody. It's not just teachers. That if you learn about, hear about, see child abuse, you are legally obligated to report that to social services. So we have laws in place to deal with the small minority of abusive parents. And it just doesn't make any sense whatsoever to keep all parents in the dark about what's going on with their own kids at school, just because you've got a tiny number of parents who are abusive.
I heard you mention an argument that there is no such thing as parental rights. I've heard that before, but I've never followed the argument at all. Are they saying in there that these rights haven't been codified or anything like that? What exactly are they trying to allege here? Because, I mean, all you have to do to flesh out parental rights is look at all of human history, as far as I'm concerned. Do you follow their argument at all for no parental rights?
Well, I think it's more of a propaganda. I mean, I think a reasonable interpretation of Supreme Court of Canada judgments is that parents do have rights to control, supervise the moral upbringing of their children and their children's education, etc. It's pretty straightforward. The people that are pushing for some sort of a right on the part of children to make irreversible medical decisions by way of puberty blockers or to mutilate their bodies by removing healthy body parts, they are fixated on children's rights. And I think it's more of a matter of language. Children's rights, you could say, yes, children have a right to the nurture and care and guidance and protection of their own parents which then necessarily translates back into parents have a right to know what is going on with their own children at school, or in any other context for that matter. I'm a parent. If I've got my kids in a martial arts class or a swimming class or hockey or piano lessons, I also have a right to know, if the teacher giving my kids piano lessons says that they want to have a certain segment of the piano lessons that's going to be secret and I'm going to be kept in the dark about it, I'm going to say no. So some of it is semantics, but there's a specter of fear that the undertone in the advocacy of the transgender movement, which is not supported by many gay and lesbian people that totally disagree with the transgender agenda. They don't even like the new flag. They like the old rectangle rainbow flag. They don't like the new one, which has got this transgender triangle in that flag, which some gays say is pushing the gay and lesbian out of the flag. But I digress. It's pushing this false narrative that parents are inherently abusive and untrustworthy, and therefore parents should not know what's going on. And I think that stems from a fundamental disagreement where the transgender ideologues believe that the only good way, or the best way to help a child or a teenager struggling with gender identity confusion is to get them on the road to puberty blockers and eventual surgery. They believe that is the best way to help a boy who is struggling with his masculine identity or struggling with his masculine body. And I think this attack on parental rights stems from that, because the transgender lobby knows that most parents, or certainly many parents, they're going to want to help their child by providing their child with counseling to help their son or daughter to accept the body that they were born with. And so if you respect parental rights, the end result is going to be that there's going to be far fewer children that are going to be going on to puberty blockers and eventually getting the surgery. Conversely, if you keep parents in the dark, you're going to have a lot more kids that are going to be put onto puberty blockers and on the path towards eventual surgery. So I think that's at the heart of it.
Okay. You had mentioned that you believe that this is going to go to court, probably challenged by the transgender lobby. Do you foresee a role for the Justice Centre in any of this? Of course, you wouldn't be bringing the action. I know in Saskatchewan, the Justice Centre has assisted some interveners. Do you see a similar role here in Alberta, or any other potential role?
That would be very likely. That we would provide lawyers to support interveners who want to intervene in the court action. This is what happened in Saskatchewan when there was a similar issue. The Saskatchewan parental policy, it was quite narrow. It was one policy about parents need to consent to children under the age of 16 doing the transgender social transition of using opposite sex names and pronouns at school. It was limited to that. To my knowledge, I don't know what Saskatchewan's policy is on puberty blockers and gender reassignment surgery, which, by the way, Danielle Smith has banned entirely for under 18. Under 18 children will not get any surgery at all, which is very, very sensible in my view. So in the Saskatchewan case, we assisted two groups, the Gender Dysphoria Alliance, which is an alliance of transgender Canadians who have gone through surgery or who have traveled down that path, who believe in informed consent and who do not agree that this is a good decision for children under 18 to be making. And we also assisted Parents for Choice in Education to both obtain that intervener status before the Saskatchewan Court of King's Bench. So I anticipate we would do likewise in Alberta.
Okay, great. Well, I guess we got some more court action to look forward to. Thanks so much for coming. Oh, sorry.
Well, which reminds me, shout out and thanks to all the donors who make it possible for the Justice Center to defend your rights and freedoms in the courts of law and in the court of public opinion. And so I just always want to thank the donors who make it possible for our team of lawyers and paralegals to fight these battles.
It does help, yes. And thank you, John, for appearing on Justice Center Weekly. I know we'll have you on again soon. Thanks a lot.
Thank you, Kevin.